All right, good morning. We are here for the self-represented family law docket. Thank you. So what I have in front of me, folks, and please correct me if I'm wrong, is Ms. Koffelt, you have initially filed, well, it looks like you guys have final parenting plans in place, but you have filed a motion to, or notice initially to relocate with the two minor children to Wyoming. Is that correct?
Yes.
Okay. And then Mr. Cook, I have received your objection and request that this court temporarily prevent the move pending trial. Is that correct?
Correct.
Okay. So I'll tell the folks how we will move forward today then. So ultimately, kind of big picture is Ms. Koffelt will need to get you on what's called a trial assignment docket so that you can have a trial on the actual permanent decision on relocation. Those types of trials do take priority. So I can work with you to get a docket scheduled that both of you can get a trial date on the ultimate, on your motion. Today, what I will be going forward on is brief argument on whether or not I can issue a temporary order, either preventing or allowing relocation pending trial. Okay. So that's what we'll be deciding today. Okay. And Ms. Koffelt, you have filed a motion to relocate with the children to Wyoming. You have asked this court to allow the move pending trial. So tell me a little bit more about the request for the move and the reason for the move out of state.
So my dad and sister are over there. They're the only family that I actually have contact with. They're my main support group. I do have family here, but toxic is toxic. My dad's health, I mean, he's getting up there in age. He is possibly going to have hip replacement surgery. So just kind of being out there to help him out. And the reason why we're trying to do it sooner rather than later is because the house that we live in currently, we rent from the church, and it's actually designated for the pastor. Well, they're hiring a new pastor. And so we think that instead of just moving to move again next summer when we actually intended on moving, we just figured that we would do it now. And school over there starts August 22nd.
Okay. And then what is the current, I did review the final parenting plan in this case, and it looked like at that time there were requests for reunification counseling to take place before any visitation. Where is the family at as far as where the children, are the children doing any visitation with Mr. Cook at this time?
No.
Okay. Since the entry of the final parenting plan, has there been reunification counseling?
No.
Okay. So one of the things I have to look at is whether I think the move would cause more harm to the children than good to the children. What can you tell me about your take and opinion on that?
Well, I know that they haven't had like any contact with John in about 2.5 years. The little bit of contact that has happened has been unorthodox. Like they heard a conversation that took place between him and his sister. There's just been minor over the phone through a third person type communication, but very minimal. Yeah, that's about it. I mean, Xander, he's still super angry about things. Logan doesn't process emotions in the normal sense. So when he is having big emotions, he has a tendency to act out.
And then I think I saw in the orders previously that the two of you have not had any prior agreements about staying in state with the children.
Correct.
Okay. Is there any sort of texting or video communication between the kiddos and dad right now either?
No, I know that there was a little bit between Xander and John. I also know that Xander, He's asked me, hey, should I text my dad, happy Father's Day? I'm like, that's up to you, and I tell him any communication that happens, I need to know about it. But that's about it.
And then if this move were to be approved ultimately at trial, how would you foresee any future abilities to engage in reunification counseling taking place?
Well, I actually did submit a new parenting plan upon John's objection, which would accommodate things as him and the children's relationship grew with the input of the reunification counselor. But I also know that those kind of counseling sessions can be done over like telehealth platforms.
Okay. And then would you anticipate any visits back to the state?
Yes, I put that also in there along with the original requirements of having to do the assessment, the strengthening for families class and reunification counseling, and then it would phase into visitations and then extended visitations.
And how old are the two minor boys now?
Xander is 17. He will be 18 in December, and Logan is 14.
Okay. And again, kind of playing through potential outcomes if the boys were to relocate to Wyoming with you, but ultimately reunification counseling was successful, are they at an age and maturity level where you would be comfortable with them perhaps flying, by themselves back to Washington for visitation and those sorts of things?
I think when the time came to it, I believe so, but I also know with Xander turning 18, it'll kind of like be up to him. I mean, he's already talked about making the drive out here to see his friends, so.
Okay. And does the 17-year-old have a driver's license?
Yes.
Okay. Anything else you want the court to know about your request for the relocation?
No, not really.
Okay, good. And Mr. Cook, you have objected to, for purposes of today's hearing, allowing the relocation to temporarily happen before trial. I just want to get your kind of in your own words. I do have your objection. I have reviewed it. I have your proposed order preventing the move. So tell me in your own words why you think this relocation would do more harm than good for the children.
Because I was led to believe up until, well, to start off with, I was under the impression that I could not contact my children, and I had contact with Kayla in the past. And she informed me that the children did not want to build a relationship with me at that time. And I had left it up to her to let me know when that changed. And I just found out a few weeks ago that my children are angry with me because I had not been in contact with them, because I haven't been trying to pursue a relationship with them. And I was never informed by their mother that that was what they wanted. I left it up to her to reach out to me when the status quo changed. And I believe she was a real advocate for reunification with my children. And it just turns out that did not happen. And as soon as I found out, then I started the process of what I need to do. I've called multiple counselors. Most of them will not see anyone under the age of 18. I finally found one that is communicating with me now. Her name is Barbara Broadhurst, and I'm working on the steps needed to start that reunification. But to my knowledge, Xander and Logan did not want to do it or participate. It was what I was under the impression of.
Anything else you want the court to know about why you think that this relocation should be denied? Oh, you're muted still, sir. Sorry.
I feel that it would strongly hinder rebuilding a bond with my children, them being all the way in Wyoming. And things weren't perfect. I made mistakes, and I've spent a lot of time working on myself to re-become who I was. I was in a toxic relationship at the time, and I let it affect my parenting, and I've worked very hard to become who I am again. And I also I have built a business and an empire to help pass on to my children and help them have more opportunities in life. Yes, Kayla is, I feel, is a great mother when it comes to feelings and all of that, but I do not feel on that side of things that there's actual, it is instilled to grow and be whatever you can be, and to, like, I want my children to do great. I was hard on my children because I wanted them to have a better life than me. And I have worked very hard to be able to provide that for them. And I feel that I can provide much more opportunity for them with having a connection with them than they can receive over there.
All right. Anything else from either party?
Well, I just know that the reunification process and the counseling, it's not going to be a overnight thing. I mean, there was a lot of trauma that needs to be addressed and that should be addressed. So I know that, like I said, I know it's not going to be an overnight process.
All right. Thank you both. I appreciate both of you supplying written materials. I appreciate your testimony today. What I have to look at in making my decision about whether to allow the move or prevent the move pending trial are 11 factors listed in RCW 26.09.520. Those are the factors that include the nature of the children's relationship with each party, prior agreements between the party, detrimental impact that the move could potentially have, whether either parent is entitled to residential time or subject to limitations under the parenting plan, the reason for seeking relocation. I do have to take into account the age and needs of the child, quality of life and resources available to the relocating party currently and in the proposed location, availability of alternatives, financial impacts. And I also have to look at the amount of time before a final decision could be made at trial. Ultimately, what the court looks at is there is a rebuttable presumption that the relocation of the child will be permitted. However, that can be rebutted by the objecting party showing that the detrimental impact of relocation outweighs the benefit to relocating the child or children in this case. My review of the written materials and hearing your testimony today, I am convinced that the ultimate move will likely be approved at trial based on the factors in RCW 26.09.520. It appears that, in my opinion, based on the evidence in front of me, that the objecting person will not be able to prove that the move would cause more harm to the children than good to the children and the relocating person. I find that the request for the move is made in good faith. I take into account the testimony today that up until now, the children have not been having in-person contact with Mr. Cook, so I don't see a detrimental impact to them living in a different state. I also take into account the testimony from the mother that she is going to continue to work on reunification with the children and the father through telehealth or other remote methods, which I think should absolutely occur, and I fully support that. I also take into account that one of these children is almost aging out of being a minor and certainly can make his own decisions about visitation with father soon. The other child will soon be in that position as well and have a driver's license. And I think both of these boys are in an age where they probably could get on a plane to visit their father on their own without mother having to coordinate that. So what I'm going to do, I don't think, Ms. Kaufeld, that you sent a proposed order temporarily approving the move. So I'll create one after docket today, and I will get it signed and filed with the court later today. You both can get a copy of that from the clerk's office. What I'm going to do is then also give you a date for trial assignment. That'll be any Wednesday that works for you. That'll be Wednesdays at 1 o'clock. you both would log on via Zoom to the universal trial assignment docket. And you would let the judge know at that time how long you expect the trial to take. You are given some preference as far as quick trial dates. I just can't promise how quick that would actually be. So what would work for the parties as far as a Wednesday to get you a trial date?
I'm open to whenever.
Okay. Would next Wednesday, July 9th, do we still have room next Wednesday, July 19th?
I believe she's already filed paperwork and we have another hearing on the 19th.
We have the parenting plan modification next Wednesday at 9 a.m.
Okay, so you'll be back on this docket. My gut instinct tells me they'll probably hold off on that until the trial on the relocation, but don't quote me on that. We do, okay. So I think what we should do, since you already have a 9 a.m. back on this docket for the parenting plan. So go ahead and keep that for now. They may bump you out, but then you'll re-log back in next Wednesday, July 19th at 1 o'clock. That will be a very quick hearing to set a trial date for you on the final decision on relocation.
Okay.
But my order today will allow the relocation to occur pending that trial. All right. So previously, I think you folks were in front of Commissioner Nelson back in June, and he did a bench order at that time modifying supervision. My understanding is we're here for a review on that because there were some concerns about the modification. But obviously I'm kind of stepping into this long-standing case here several years later. So maybe Mr. Lawrence, I'll first turn to you to kind of get me up to speed on where we're at.
Yes, Your Honor. This has been going on for several years. The primary issue was Shane suffers from bipolar disorder, and he was untreated initially, and he did some bizarre behaviors that not only scared Tasana, but scared Shane's family as well. He was running through the neighborhood in just his underwear, jumping up and down on his own car. He assaulted a couple of workers that came to inspect his foundation. And ultimately, Shane got his medication straightened out. And for about the last year, he has been pretty stable. One of Shane's issues was smoking marijuana, and that seems to be under control as well. We were before the court a few weeks ago, and the concern was whether or not Shane has been taking his medication as approved or as prescribed. He supplied me with a blood workup from May 19th of this year, indicating that he was current and doing well. Shane is working full-time, has a place of his own now, and has stabilized quite a bit. Tasana was involved in a car crash, I believe last summer, and she had been drinking and under the influence of marijuana at the time, and she was charged criminally over that. And my review of the Odyssey documents indicates that recently she accepted a plea agreement and is to be sentenced on August, I think, the 13th. And she is looking at a potential sentence of 12 to 16 months in prison. Mm. The question then became, what happens to Abel, who is about, I think, 5 or 6 now, because Shane had not been stable for a long time. There was concern as to whether or not Shane could actually provide for him while Tasana was incarcerated. Tasana had asked about a year ago to move to Hillsboro, Oregon, to relocate with her boyfriend, and that apparently did not happen. And she is currently still living with her parents in Woodland. And I have spoken to her mother, Sandra Burkett, who indicates that they are more than willing to care for Abel throughout her incarceration. But we still could continue with visitation with Shane, and potentially as he maintains his stable situation, we could consider maybe increasing some of that visitation with Abel. And so that's kind of where we're at this point. And I haven't spoken to Tasana since her plea agreement, so I don't know further than just what I read in Odyssey. And I haven't spoken to Shane in the last week or so either. And so I don't know his position yet either.
Okay. That does get me up to speed. I appreciate that. So maybe I'll check in with the parties. And well, first, I guess, Mr. Lawrence, let me ask you, so I'm trying to make sense of whether we have a parent. The last thing I see was in 2022, a motion to change the parenting plan, or a motion for adequate cause to change the parenting plan. An adequate cause was found, but then I'm not seeing whether there was ever a full hearing or trial on changing the parenting plan. Are we still kind of in that setting?
There was no trial, Your Honor.
Okay. So I think for my purposes, just procedurally, I see essentially we have an unaddressed modification to a parenting plan hanging out there. But if this is going to be a situation where one or both parents can't be full-time parents, my thought is that there might need to be an emergency minor guardianship case started if there are other adults that are going to be taking over that role.
We initially thought that if Tasana was in Hillsborough and went into jail, that there would be nobody available to care for Abel. However, she did not move to Hillsborough. She remains living with her parents, who she has lived with for a number of years, and Abel considers that his home.
Okay.
So if she were to go to prison, then Abel could continue staying with his grandparents, and Shane could continue with his visitation.
Okay. So, Ms. Burkett, let me turn to you. What is your, I guess, status? You've heard some of the testimony or statements from Mr. Lawrence about an upcoming potential sentence. Do you have any more information to give the court about that, so we can kind of craft how to best take care of the child in the interim?
Yes. First, I just wanted to address, I believe Keith said the accident happened last summer. It was actually 2.5 years ago that it happened. And I have been 100% clean and sober ever since. I just had a hair follicle test and everything came back negative. And we are going forth with a plea deal with a parental sentencing act. I qualify for all of the things that were needed on that list for the parental sentencing, which would prevent me from going to prison. So that's what the defense is going forth towards at this moment.
So then would that be more like electronic home monitoring or something where you would still be at home?
Yes, it would be probation from home.
Okay.
Yeah.
And when does the sentencing take place?
August 16th.
Mr. Llewellyn, I'll hear from you. I mean, we're on essentially for review. My initial thought was we were reviewing the visitation that had been changed back in June, but it sounds more like we might be doing kind of some future planning for the child. What do you want the court to know about how things are going right now?
So I haven't seen Abel in about a month. It would be a month by the time I next see him. I was allotted 40 hours with him, but then we switched it to 36 because she tests wanted weekends with him. And I didn't get every Wednesday. Instead, I got every other Wednesday. So I lost the 4 hours. Last time I saw Abel was some Saturday, June 10th for 4 hours, and then Sunday, June 11th for 4 hours. I'm supposed to get 8 hours each day with those. And then the 24th of June and the 25th of June, I got 0 hours, as well as this last Wednesday, I got 0 hours. Saturday, the 8th, 0 hours I'm getting, or I guess that's today, sorry. Today I get 0 hours. No, I'm a little lost.
It's-
I've
it's
lost
okay.
a lot of time with him, like
It's
a
okay.
lot of time. And it's like a month since I've last seen him. So it's Wednesday, June 21st was the last time seeing him. And 1 month time will be passed by the time I get to see him again because I missed my last weekend. And since it's every other weekend, I'm
Mhm.
missing this weekend too. So I'm proposing that I get to see Abel today and this Saturday and that we reset the schedule because it'll be a month without him or I seeing each other.
Yeah, so what's the reason?
Yeah.
What's
Sorry.
the
Your Honor.
hold on one sec. What's the reason? You said you missed visitation last weekend. What was the reason for that?
The supervisor has been a difficult one, not her herself, but just her supervision. She does bartending gigs over the weekend and she has her own life going on with all kinds of stuff. But this last weekend, her mom had passed away. So I missed my Wednesday, the Saturday, and the Sunday. And then, like I say, the weekend before, I only got half my time. And it's typically I get either half or none of my time. Like I was allotted 40 and I'm getting like 10 to 15. Well, I guess 36 now, but I'm not getting nearly as much as I was told the court that I could have. I would like to see if we can go about getting the unsupervised visitation with everything that Tess has going on, whether it goes to where she ends up in prison or whatnot, or if she does the FOSA, which is what I was told by the court, Family Alternative Sentencing Act or something. If that would be the case, then I would be able to take Abel anywhere, do anything at our times and get my full allotted time. And it just doesn't really seem to make any sense to me because if whatever ends up happening, she has got a restraining order on me and she's the one that's been doing the pickups and drop offs. And with the restraining order, I can't really necessarily go pick him up or drop him off. Plus the fact that her parents really don't care for me. So they're not going to want to do the pickups or drop offs. And they're not going to want me to go there to pick up or drop off either. So if I could just get my unsupervised visitation, like I've been doing extremely well. I'm actually nearing or at the 2-year mark, not 1 year of stability. I've jumped through all the hoops that they wanted me to. I went through reconnecting families. There was not a single bad note said about me. I take my regular urinalysis for showing that I've taken my medication and have no THC, and it's a like multi-panel. Like I was impressed with how many different drugs it goes through, and all of them come back negative except for my medication. And I've just been doing everything that I can in the best interest of Abel and wanting to see my son more, and it hasn't worked out that way as was told by the court.
So here's where the court stands. I do show back on October 31, 2022, you all were in front of Judge Basher, a Superior Court judge in this county, who did conduct a non-jury trial on visitation and did set the every other week schedule at that time. Absent a request for a new trial on that, I would not be inclined to change it. I do note you have somewhat of a modification here that adds in every other Wednesdays from 5:30 to 7:30. Today, what I'm going to do is keep that visitation as scheduled. I believe Judge Basher's findings are appropriate based on the fact that he was able to actually take evidence on this and set the appropriate visitation. Looks like Commissioner Nelson took into account some additional information to do a slight modification of that. So for now, the June 8, 2023 modification of visitation will stand. What I would like to do is set a review date just after August 16th. So the parties can come back and we will know for sure what Ms. Burkett's sentence is. I think that is going to be instrumental in determining whether we need to take any further steps for custodial parentage of the child, or if she is going to be essentially home and able to maintain that role. So let me get my calendar. Okay, so let's set you all to Wednesday, August 23rd at 9 a.m. back on this docket. And that will be to review whether we need to address any parenting plan changes if Ms. Burkett is unable to be primary parent for temporary, a 12 to 16 month period or whatever that may be, or whether she is able to remain at her home.
Your Honor.
Yes.
So do I just lose out like on an entire month of not seeing my son? And not only that, but during one of the last like 3 court dates ago, we had spoken, I don't remember which judge it was, I want to say Basher, but he was talking about getting unsupervised visits as well as overnight stays. And I know that that changed the last like 2 ago, but that was something that was already talked about. And I feel like this is just kind of just getting beat around the bush kind of thing. And it's just been very hectic with the supervision. I mean, the supervisor for the visitation. So if we could try to speed that along, or if I could at least get to where I can see him without waiting an entire month, since I'm supposed to see him 36 hours a month, that just doesn't really seem fair to him or myself.
Yeah. What I can say at this point is I'm going to follow the visitation that is currently in place that was set by both Judge Basher and Commissioner Nelson. If you want a change to that, I would request that you file a motion to change that. So I think what's happened, and this is through no fault of your own, I know the parties are unrepresented, but essentially it looks to me like this case, there was a trial, visitation was decided. Typically that is the new parenting plan. But in your case, just review dates were set where a commissioner would review the case and decide whether to make modifications. But truly, if we're wanting to change a parenting plan, we would need to go through a new fact finding. There would need to be new evidence that this is in the best interest of the child. So I'm not inclined on this hearing without any further evidence in front of me to make changes to that visitation schedule. But if that is a motion that you want this court to decide, please bring it forward with the evidence you have to show that that change would be in the best interest of the child.
May I ask, Your Honor, if it were to be worked out with Tessana, could we not switch it like indefinitely, but like just to where I get my visitation with him, and then we could go get back on track again with the one that's already proposed by the courts, even if it's just like partial time that I could see him and then we continue with the regular schedule, or if I could see him this Wednesday and weekend as well as next to make up for lost time, or something that would work best for both parties as well as April's interest.
I understand your request. I think my hand, all I can tell you is from the court's perspective, there's an order in place that needs to be followed. If the parties come to an agreement that is different than that, I'm not going to say one way or the other, whether that's court approved or not. Certainly no one's going to be held in contempt over something, an arrangement like that. But as it stands now, all I have authority to do is to tell you that the order for as currently filed with the court is going to stay in effect.
Yes, sir. Okay. May we voice that over here to see if the other party is okay with it? If we could work something out, even if we don't.
I've got many other cases I have to call. If the two of you want to work on that through a third party, I have no problem with that. But I think we've set your review date. So I'm going to end your case here today. The two of you will be free to log out. We'll see you back on August 23rd. Primarily to discuss the Ms. Burkett's sentence. If you want the court to look at a motion with further evidence about visitation at that time, please go ahead and file that. Okay.
Okay. May I just ask, Your Honor, I don't mean to be pushy, but could you just ask?
I've got to move on to the next case, sir.
Like
so I can't give legal advice.
No, it's not legal advice. I was just asking, would you be willing to ask Tess if that's something she would do? Just a yes or a no answer. So it can be stated here on the courts.
Ms. Burkett, did you hear what his question was? I think it's about making up visitation time that he's missed.
Yes, and I normally would, but we had made plans this weekend to be out of town, Abel and I. I tried to make things, plan things ahead for weekends that I know I'll have him.
All right.
So,
okay. So that is the answer for Ms. Burkett. So the two of you are free to log out. We'll see you back on August 23rd. Mr. Lawrence, anything else you need from the court? By my notes, and again, this is a case I recognize I am stepping into after many things have occurred. But the last item I see is Commissioner Nelson suspended visitation for Mr. Gutierrez and ordered that you obtain a drug and alcohol evaluation. We were going to wait for some collateral input from Mr. Lawrence on that, and then we would discuss future visitation. So first, like Mr. Lawrence, similar to the last case, I'll turn it over to you to fill in any gaps I may be missing, or let me know if that's your understanding of why we're here today as well.
Yes, that's correct, Your Honor. The kind of brief report, on Memorial Day weekend, Mr. Gutierrez had the children on a visit.
Okay, hold on one, just sorry to interrupt you, Mr. Lawrence. Mr. Gutierrez, there's a lot of background noise happening on your end. Can you just mute until I take testimony from you?
Okay.
And Ms. Gutierrez, I'll have you do the same. Just keep your camera on, but just mute it until we have you testify.
Okay.
Okay, go ahead, Mr. Lawrence.
There was some miscommunication. Mr. Gutierrez lives with his sister in Vancouver, and they share an apartment together, and the kids came down for a visit, and Alyssa was aware that Mr. Gutierrez goes by Julian, his middle name. She was aware that Julian was going to be working some during that Memorial Day weekend, but she didn't know the exact days. And the same thing with his sister, knew that he was going to be working, but again, didn't know all of the days he was going to be working. So what happened was the kids woke up on Saturday and Mr. Gutierrez wasn't there. And so they were concerned as to where he went. And he came back in the afternoon, and the one child, Carson, indicated that he thought that his dad was drunk. And Mr. Gutierrez's sister indicated that no, she didn't think he was drunk when he returned from work, but that he did have 2 or 3 beers after he got home. And again, Mr. Gutierrez was gone on Sunday, and his sister went to watch her husband play soccer. And so the kids got up and there was nobody there. And Carson called his mother, and Ms. Gutierrez then requested a welfare check from the police. And ultimately it all got straightened out, but there was allegations of drinking. There was allegations of leaving the kids unattended due to poor communication. And the reason that we're even here, why the divorce was based on an incident in which Mr. Gutierrez became intoxicated on a New Year's Eve. Anyway, Ms. Gutierrez then was able to find a position in Ellensburg, Washington, as an apprentice dental assistant. And at the last hearing, we were addressing whether that move should occur. And we also then addressed the visitation by Mr. Gutierrez, and Ms. Gutierrez has wanted him to undergo a substance abuse evaluation, which he was not obtaining. So I had recommended that the visitation be suspended until he obtains this evaluation with Alyssa and my input. I checked Odyssey yesterday. I did not see any evaluations filed in Odyssey. I also did not receive any kind of a request from any evaluation agency requesting my input on his evaluation. So my assumption is that he has not done that yet.
Okay. Thank you. Mr. Gutierrez, let me, on that specific point, if you want to unmute, have you been able to comply with the commissioner's order to obtain a drug and alcohol evaluation yet?
No, I have not, because I don't know where to go or number to call. I honestly don't know exactly what that is. All I did was I did do a drug test, and I screenshot pictures of the results, and I emailed it to Mr. Lawrence, and that's all I've done. But as far as an evaluation, I haven't done it, because I mean, if I could have some sort of a paper of instructions or something, a number to call so I can go do it, or maybe I get more time to get on it, I have no problem doing it.
Yeah, and Mr. Lawrence, I don't know if part of your resources include facilities that do these kind of services where Mr. Gutierrez is located?
I can find out, Your Honor, and make that information available to him.
Okay, let's do that. And my thought is we'll set a review date. Now, typically I would just do a 30-day review date so that we can, address visitation sooner than later. Mr. Gutierrez, I'll somewhat leave it up to you. I know the first step is that you'll have to call and get the appointment. I do know that getting those appointments can take some time. I doubt that you'll get in and have a report within 30 days. But I'm happy to do a 30-day review date if that's the party's request. Otherwise, I would propose 60 days, which I think is more realistic. What would be the party's preference on a return date? Mr. Gutierrez, since it's your visitation kind of on the line here, are you comfortable with a 60-day review date to get that done and come back to court?
I could do 30 days. I could do 60 days. It doesn't matter.
Okay. Well, then maybe we'll split the difference and do about 45 days. So that would put us at 30. Let's look at Wednesday, September 13 at 9 a.m. Will that work for the parties?
Sure, yes.
Okay. Mr. Lawrence, does that work for you since we'll be looking for your input again?
Yes, Your Honor.
Okay. And Alyssa, does that work for you?
Yes.
Okay. And I apologize, Ms. Gutierrez, I didn't come to you for any input. Is there anything else you want the court to know for today's purposes?
No, I think that he's capable of getting it done within 30 days. I reached out to Kaiser. We both still have the same health plan, and they got back to me and told me that his drug and alcohol counselor that he had tried to see before would be willing to do the assessment. He just has to call.
Okay. And what I'll say is if both parties want this matter heard sooner than September 13th, let's say the report does come back and you want me to take a look at it to review any modifications to visitation on, if the case is truly ready for me to review sooner, you can certainly note it on earlier than September 13th.
Perfect.
Okay. Okay. Otherwise, I'll see the parties back on September 13th and we'll address the review of the evaluation, any input from Mr. Lawrence and talk about. And Mr. Culbertson, I understand you represent the respondent in this matter. Is that correct?
That's correct, Your Honor.
Okay. And Ms. Jackson, are you still with us?
Yes, I am.
Okay. So what I need to do on this case, this docket, the folks got set on this unrepresented docket because we at that time didn't have notice of representation for respondent. I do need to set you over. I need to move you guys now permanently to our represented docket. And what would be the next date we could get them on the represented docket?
Your Honor, I actually cited it on for the 18th on the represented docket.
Oh,
So
you
it may
did?
already- Yes.
You may already have a date. Okay. So yeah, it looks like you're on for Tuesday, the 18th. Is that on the 9 a.m. or the 1 o'clock? 9 a.m. Is that what you have, Mr. Culbertson?
Yes, it is.
Okay, so we'll go ahead and strike your appearance here on this docket. Ms. Jackson, you will be appearing for this matter next week, July 18th, which is a Tuesday at 9 a.m.
Okay.
Okay.
I have one more question, if that's, so since I have not received any response from him, and I mean, he doesn't really have a physical address or office, the attorney, but I just want to make sure that I can stay in the house at this point, because we had on Monday, we had the hearing with you.
Yes, yes.
And you're supposed to decide who is staying in the residence. I have been staying in the
So I
residence.
could not, so ma'am, so first, I'm not going to be deciding that issue. You were in front of me and Mr. Culbertson, for your information, both parties were in front of me as the commissioner on the civil protection order docket on Monday.
Mr. Culbertson wasn't there.
No, Your Honor. My client was there, but
Yes.
I wasn't there.
Correct. So yeah, I was just filling you in a little bit since I was the commissioner who heard that. And Ms. Jackson, what happened at that hearing is that I denied and dismissed your request for a protection order.
Yes,
You
that's
did,
correct.
you did at that time ask me about who stays in the house, and I said, I'm not making that decision. I was hearing your case only as deciding your civil protection order. I noted that there still is a no contact order in place from the criminal case, and that you were all to follow whatever the requirements are in that protection order. So that's all I can tell you again today, but please,
Okay.
please readdress that question when you get assigned to a new judge on the represented docket on July 18th.
Well, so it says in my paperwork, the right to possession of the residence at 124, but the address will be decided by the Superior Court in case number. You dismissed on Monday the restraining order, but you're supposed to give us who can reside, because it's even
I am
written in
not-
paperwork from you.
I am, so number one, that is not what I am doing today. You are
Okay.
welcome to address that on July 18th at 9 a.m. to the assigned judicial officer for that docket.
Okay.
Thank you. Mr. Culbertson, any questions for me?
No, Your Honor, I just wanted to say that I did serve her with the response personally on the 26th. I haven't filed the proof of service yet.
Okay.
But it was at the courthouse, at the
Yeah.
Callis courthouse.
Yeah, you served me, but this is all I had from you so far.
Okay. All right, thank you, ma'am. So you can address these questions at your hearing on July 18th. Mr. Culbertson, thank you for sticking with us, and Ms. Jackson, thank you for being here. Log back in next Tuesday, okay? Okay, so all right,
Okay.
parties were here on thank you. June 14th in front of Commissioner Nelson. It looks like we were discussing visitation and vacations potentially at that time. The commissioner set this review hearing. It looks like to continue that because there was not, I don't see any formal order issued out of that hearing. So again, Mr. Lawrence, much appreciation to you. If you want to fill in any gaps for me, the court would appreciate it.
Yes, Your Honor. Mr. Utter goes by Stevie. Stevie and Kirby had this child, Parker. And at the time that Parker was born, Mr. Utter was married to a woman named Autumn. And Autumn became very upset about this child and threatened to kill Ms. Young and the child. And so Mr. Utter decided to essentially stay out of Parker's life for the past 10 years. And Parker then discovered that Mr. Utter was his biological dad. And so we've been talking about how to reunify these two and have a father-son relationship. Parker is a rather reserved young man. He doesn't like to be pushed, and he has some definite ideas about how this reunification should take place. We initially discussed reunification counseling. I don't think truly anybody really wanted that. And so Commissioner Nelson at the time decided to start just having Mr. Utter have visitation with Parker while Ms. Young was in their presence, essentially a supervised visit by her. That went well. There were phone calls and those went well. And so we decided then to move to the next level where Ms. Young has Parker involved in horseback riding lessons and other activities. And the commissioner wanted Mr. Utter to be included in those activities with Ms. Young being present. And those went very well. And so we were talking about essentially ratcheting up the amount of time that Mr. Utter could spend with Parker. And as Parker becomes more comfortable with him, then Ms. Young could kind of fade into the woodwork and leave Mr. Utter and Parker together. And that's where we were at the last hearing. that very evening, I got a call from Mr. Utter indicating that Ms. Young's boyfriend, a gentleman by the name of Jeff McDonald, who has an extensive criminal history and is apparently physically abusive, was at Ms. Young's house that evening. And the police got called. So I asked Mr. Utter if he could get a copy of that police report for me. I spoke to Ms. Young about it, and her indication was that she came home, had Parker in the car, and saw Mr. McDonald's car in her driveway or out on the street near her home. And so she just continued on past her home and called the police to have him removed. She denies any kind of involvement or contact with Mr. McDonald, and that there was no contact between Parker and Mr. McDonald. I still have not received the police report. And so we're here, I guess, to address that issue and to see where we go from here as far as the visits.
Okay. And I will turn it over to the parties here in a minute. I'll just say, Mr. Lawrence, thank you once again. And my review procedurally on this case is that we have some bench orders addressing bits and pieces of this case, but unless I'm missing it, I see there was a motion filed back in February of this year to get a temporary parenting plan put into place. But I don't see that a judge or commissioner has ever signed a temporary order establishing a parenting plan or child support or anything like that. Does that meet with the parties' understanding?
To an extent.
Okay, go ahead, sir, and let me know your perspective on this.
So Mr. Lawrence, though his telling of events is pretty accurate, it is pretty vague. There's a lot more to that. We could be here for a long time.
Oh, no, sure. So, sir, what I'm asking for right now is procedurally, has a judge issued a decision on a temporary parenting plan for you all? Other than received bench orders, kind of addressing bits and pieces of visitation. But I know, like Ms. Young she filed a motion back in February saying, I would like the court to adopt my parenting plan. There was a hearing held, but no order signed, except little kind of bench orders. Does that meet with your understanding, Ms. Young?
Yeah, they were kind of doing the visits like what we've been doing, so they can kind of get to know each other is what the judge, but that was it.
I have been paying, Your Honor. Sorry.
No, I see that. And is that the $150 a month?
No, weekly.
A week.
Weekly. Okay. And that's interesting too, because that's not a child support order. It really is just a bench order. So I think procedurally what I need to do is set this for an actual hearing on presentation of temporary orders. Given some of the things I'm hearing, I think we will want input from Mr. Lawrence upon further investigation on some of those items. You all will be, it's kind of like a mini hearing in front of me where you do present testimony to me about why your proposed parenting plan is the one the court should adopt. So what I want to do is set a date for you all to have presented to me your own proposed parenting plans. So that these are forms you fill out and submit to the court, and it's just called a temporary parenting plan. And you both submit to me what you want and what you're asking for and why. And then we'll have a hearing. Mr. Lawrence will be a part of that. If you want to submit any declarations in support of why you're requesting those things, like family members or other people who know what is happening in this family dynamic, you can submit that testimony by declaration. And then I will have a hearing with you all, and we will actually sign and craft a formal, full temporary parenting plan. Then the next step would be you all would set a trial date for a permanent parenting plan once you're ready for that.
Okay.
Very good.
Okay. Does that, I think that kind of, I know there are some major issues we need to address. So I'd like to get this set sooner than later, but procedurally, I need to get all of these kind of piecemeal bench orders put into one formal temporary parenting plan for you all.
And that's why I brought this to the court, Your Honor, for that reason, for the help to get us together and facilitate a relationship. And that's exactly since February. I've submitted that parenting plan, temporary and stuff like that already. So thank you.
Okay, perfect. So how much time, now things have changed maybe since this case was first filed. So I want to give the parties opportunity to file new proposed parenting plans. Unless what you've already filed with the court is still what you are requesting, that's fine. But I'm guessing there might be some changes to what you originally wanted in February. Does that sound correct?
Probably. I don't remember now, but.
Okay.
I don't think we need any changes on my end, but.
On your end? Okay. Let me make sure I have something from you just before we.
Yeah, I'm the one who's brought this to the courts and submitted it, so I don't know.
Okay, I do see yours back from February 3rd. I do see your proposed parenting plan. You did petition for a parenting plan, and there's a motion for a family law order. And you have a declaration in support of your parenting plan. But what oh, no, hold on. I had to go back further.
I know we spent a lot of money and did a lot of papers.
Yeah, there's a lot here. So Ms. Young, what I do have from you is a February 10th proposed parenting plan. And that's the one, Mr. Utter, you would want to actually file with the court. You have filed all the other paperwork except that one document.
Okay.
So what it's called is a parenting plan. It's your request that's going to include what you want holidays to look like, what you want school schedules to look like, what you want summer schedules to look like. That's the only thing I'm missing from you, but you filed all the other things.
Okay. I'll get right on that.
Okay. So how much time do the parties want before we come back and have a hearing on temporary parenting plan?
So I have a question. So for the paperwork, for having like, people, witnessing or whatever, that all gets submitted too?
Correct.
Before...
If you want to submit declarations, you can. Just know that there are some local rules on how long those declarations can be. If you want to look those up, it's Cowlitz County Local Rule 88.
Okay.
So you may want to take a look at that. My general advice is the shorter, the better. We generally want to see those under 4 pages long.
Okay.
Yeah.
Okay.
So how much time do the parties want? Do we want to set this out like 3 weeks or 4 weeks?
Let's do 4 weeks.
Mr. Lawrence, would that work for you?
Yes, Your Honor.
Okay. I know there were some, so let's do that. We're going to schedule this August 9th at 9 a.m. for presentation and decision on a temporary parenting plan. Do we, Mr. Lawrence, in your opinion, need to address, I guess, anything on an emergent basis in the interim as far as visitation?
The only thing is Mr. McDonald should not have a presence in Ms. Young's home. He's got an extensive history. Ms. Young has indicated they are not seeing each other, that he is not living at her home. And whatever, if Mr. McDonald shows up, Ms. Young take all appropriate action to have him removed.
So yeah, Ms. Young, let me ask you about that. Is this gentleman physically present in your home at either permanently, temporarily, or any part of the day?
Not at all.
Okay. If I issue an oral ruling today, essentially adopting Mr. Lawrence's recommendation that this individual not in any way be physically present in your home permanently or temporarily, and certainly not around the minor child, can you abide by that?
Yep.
Okay. I think that likely will become a formal written order in our temporary parenting plan, just given the concerns the court would have about criminal history. But please know that is the court's ruling today, and we just, urge you for the safety of the child to take that seriously.
Yep.
And it sounds like you are.
Yes.
Okay. Okay, anything else the parties need from me? Otherwise, we'll be back on August 9th and start working towards some resolution of these issues for you all.
Okay.
I would actually, Your Honor.
Okay, go ahead.
Can we get some more? Our visitations have been very, very good. Parker's really coming out of his shell. He's had time alone with me without her present. He's come into my home to get his football cleats. I did ask him if his mom knew he was there. He jokingly said no with this big smile and said, Parker, let me know. And so I called Kirby and I said, hey, Kirby, Parker's here. Just want to make you aware. And she was. My son had went over and got him. She had said she would be there in 20 minutes to pick him up. So I relayed that to Parker. We went to this pool to go swimming and he was pretty upset. He only had 20 minutes. It ended up being longer than that. Thankfully, it was a little over an hour. But he was still upset that he had to go. He wants to have more time. So I was wondering if the courts would kind of ensure that our visitations are doing really well. Our communication doesn't seem to be doing the greatest.
You mean the communication between you and Ms. Young or you and the child?
Miss Young.
Okay. So what
Can
are,
sorry.
what are you asking of the court today?
So right now we're supposed to have, I mean, it's pretty lax, which is nice because our schedules are so busy. But there has been times where if I know a day we can see each other, a date he might be come over, I can rearrange scheduling a little better that way instead of being, oh, this works here. Oh, wait, it's not going to work this day, or something along those lines. More structured.
Yeah, and here's what I would say, that's my goal in the hearing we're going to have in 4 weeks.
Okay.
So certainly I think that will definitely should be a part of your proposed parenting plan, kind of making sure that you're requesting what works for you and the child, and Ms. Young is requesting what works for her and the child, and then we'll come together, make that decision. So I probably am not going to make any sort of ruling on that today, but certainly that is the goal for getting you guys some real structure in this case, which I don't think you've had yet. So, okay. Ms. Young, if you want to add anything, or are you satisfied with that?
Nope, that sounds good. And just to clarify, like they're supposed to do 2 calls a week, which those have not been happening. And I think Stevie knows those are on Tuesdays and Thursdays. So I think those are really important. Those kind of help Parker kind of in between the visits, but those have really almost come to a complete halt. So I just asked that, because I think Stevie's out of town for this whole week. So no visits this week, and the rest of the visits have been, like he said, our schedules are kind of crazy. So I just don't want there to be so much time in between the visits, I've noticed with Parker. So those phone calls, especially this week, are obviously very important. And I seem to reach out to Stevie a lot of, hey, what's your schedule? Call, so I just want those to continue if at all.
This is where the
possible.
miscommunications are coming.
Yeah. So, I mean, I would say right now, all I can do is say, follow what is in place under those bench orders, do the best you can. Let's regroup in 4 weeks and give you guys some more structure to this, because it sounds like both parties are requesting that. So,
Okay.
okay.
Perfect. Thank
Do the best
you.
you can until then.
Your Honor, my
Okay,
phone is
thank
open
you.
all the time. He can call anytime he wants and vice versa. So
Okay.
there's no worries on the phone calls on my end.
Okay. Well, I appreciate you guys working on that. Okay.
Thank you.
Anything else we need? Otherwise, we'll see all the parties back on August 9th. Here.
Perfect.
I did have a guardian ad litem noted on this case. Is she still involved, to the best of your knowledge?
No, she's not, Your Honor. She had a conflict and had to withdraw.
Ah, okay.
Another guardian was ordered but has never been assigned because there wasn't one available to assign to us.
Okay. Well, let's talk about what I see from the last hearing. So back on June 7th, you were before Commissioner Nelson. It looked like reunification counseling was the primary topic of review. Ms. Lakey Jones, at that time, it sounded like perhaps you might be making a motion based on how those things were going. I haven't seen that yet, but certainly you still can file whatever you would like to file for future dates. So what's the party's understanding of what you're asking of the court today? Or did the commissioner simply set this on for a review of reunification counseling update?
It's my understanding that it was just set for a review. And
Okay.
honestly, at this time, if Mr. Lakey's in agreement, I think we just need to be set over again for another review in 2 to 3 months. His DV treatment is ongoing and reunification counseling is ongoing.
Mr. Lakey, is that your request and understanding as well, or what are you asking of the court today?
That sounds fine, Your Honor. It's
Okay.
been going good. Group has been going good and everything.
And then I'll just say kind of procedurally, what I see is that you guys have temporary orders that a judge has signed, and those have been in place since October of 2022. Ultimately, the goal is to get you all final orders and you can get the court out of your hair, so to speak, at some point. Do you folks feel like you are ready? I guess maybe after the next review, we can make that decision, but ultimately the goal would be either there are agreements on the permanent family law orders, or you both can't quite agree on every little detail. So we would set you for a trial to finalize this case and the final orders. Where are you all at in wanting resolution with final orders?
I would love to have resolution for final orders, and I would really welcome the opportunity to sit down with Mr. Lakey and try to do that together. But I don't know if we will be able to do that or not.
Okay. Mr. Lakey, what's your perspective?
I'm open to it and everything, so.
So let's do this. Let's set you for a review on the reunification counseling, because I think you'll both want that done before this went to trial. But then I'm going to make a note for myself, assuming it's me or whatever judicial officer is at your next review, we can discuss whether to set your case on for a mandatory settlement conference, which is where you would meet with a mediator and discuss whether, see if you could come up with resolution.
Okay.
Okay. Okay. And so you said you're asking for about 2 months review?
I think that would be fair, 2 or 3 months. Yeah.
Okay. So let's put you to September 13th at 9 a.m. as your review date. We'll specifically review reunification counseling. And then I'll check in with the parties about whether we need to get you set on a trial assignment docket or scheduled for mandatory mediation.
Okay, sounds good.
Okay, anything else you need from the court?
No, not that I can think of, Your Honor.
Okay.
Nothing for me.
This,
sorry.
what I have in front of me is a motion and order for contempt. And it does look like I have an affidavit of service. And sir, since you're here, I presume you've been served with the motion and order.
Yes, I have, Your Honor.
And then I'm just going to look and see in my, okay, I do have a proposed contempt hearing order. Ms. Lawrence, is it still your plan to move forward on your request for a finding of contempt?
Yes.
Sorry, I can't hear you. You might need to speak up a little bit.
Yeah.
Okay. And it looks like your video's freezing. Since I have seen you, if you want to go ahead and turn off your video, I think that'll give you some more bandwidth. Okay.
Hear me?
Sorry, try that again.
Are you able to hear me?
I am. Just make sure you speak loudly. It is a little bit low. But go ahead and tell the court, it looks like you're requesting contempt based on failure to follow a parenting plan by withholding the child. So tell me anything else you want the court to know.
I would just like my son to be returned to me. He will only allow me to see our son under his terms. He wants to be present anytime I see our son, which isn't what our parenting plan states. He won't allow me to have my son in my own home. And I had met with an advocate because I was previously represented by an attorney, and I had thought that our proposed final parenting plan was in place, and I just recently learned that it was not.
So
Correct. Yeah. The last thing I see is the temporary one from last February of 2022.
yeah, so I was told that we might have to do a mediation hearing since we both can't agree on a parenting plan.
Okay.
But, and I would like to do that, but I would like to have time with my son.
The temporary parenting plan that's in effect, and I don't see any orders that supersede that, give custody to you, ma'am, and fathers only to have professionally supervised visitation once a week for 2 hours. So has that changed? And I'm just trying to figure out why he would have the child at all, given that order. That is the most recent thing I see signed by any judge.
So we did try to work things out and get back together, but it didn't work out. Nothing changed. The behaviors were still the same. So I got my own place and I'm trying to do better for me and my son, but he is withholding my son from me now.
So, sir, let me turn to you. The only judicial order in effect precludes you from having anything other than professionally supervised visitation. So what's going on?
Yeah, I'm actually a bit confused as well. I recently actually went to legal financial aid to get a better understanding as well, because we were together for a while now. It's she actually just recently left about a month ago, and even then she didn't have her own place. She just was it's been a constant stress and issue since the beginning of her leaving, coming home, and she would never take Jackson ever with her, which I thought was weird. She would just always leave him at home, which was with me. And we've been together fixing all this. She is still actually currently on my lease right now where we're living at. So it's just a little weird that she gets to choose and pick when the parenting plan goes in place, because I was told there was never one. And then she just recently is trying to kind of use that against me. I don't know if she's using our son as kind of like a revenge or whatnot, but Jackson's been with me every day for, I would say probably it's been like definitely 6 or over months. She was also with us in the house. She just herself decided to leave. And actually just the other day we had a phone call that was about almost 2 hours long, talking about it. Even then she was wanting to fix things and all this, and she was confused, wasn't sure what she's wanting.
So sounds like this needs to go on for lengthier fact finding. There's a lot of moving parts here. I mean, technically, sir, you are absolutely in violation of the temporary parenting plan, but it sounds as if since the temporary parenting plan was put into place, Ms. Lawrence may have agreed to allow direct contact with the child and herself by moving back in. So I'm not sure anyone is following the temporary parenting plan. Have you folks had a guardian ad litem on your case before?
No.
Okay. I'm going to appoint a guardian ad litem to be involved in this case. And then I think that we need to start moving this towards resolution, which could be referring you for mandatory mediation or setting of a trial date. Okay. Was Amy Turnbull the first one? Okay. So we will assign Amy Turnbull. We're going to set a 30-day review. The hope is that the GAL has had some contact with the two of you by that time. So then we'll go out so you'll have a couple review dates and you all will get this paperwork, or you have access to it at the clerk's office. So your first review date will be August 9th, and then we'll set a review date for September 6th. And then at this time, I am putting a note in here under other orders that until our next review date, parties to abide by the 2/8/2022 temporary parenting plan in effect. And then are the two of you in agreement for me to indicate your agreement to this appointment via Zoom on behalf, Ms. Lawrence, on your behalf? Mr. Kozar, do you approve this order via Zoom?
Yes, Your Honor.
Thank you. Ms. Lawrence, I'm going to try and hear from you again. Do you approve this order via Zoom? Okay. Having not heard anything different, I am going to indicate your agreement via Zoom.
Yeah, sorry, I wasn't able to hear.
Oh, there you are. Okay. Okay. I'm going to get this signed and filed with the court today. And so your next review date will be August 9 at 9 a.m. and we'll formulate a plan from there. In the interim, I think because I do find that the temporary parenting plan is not being followed. However, I don't find that that was a willful failure to file it or to follow it. It sounds as if the parties may have worked on reconnecting and that has not worked out. And so I'm going to deny for now the contempt motion. However, Mr. Kozar, since my order today does include language that the February 8, 2022 parenting plan remains in effect until the order issues the court orders issues a further order, you do need to abide by that. And right now that would not allow you to have custody of the child. So I just want to make that clear on the record to you today. We'll readdress that on August 9th. Any other questions of the parties?
So when is he supposed to be returned to me? Because I haven't seen him for over a month.
Yeah, I would say immediately. Otherwise, I think, sir, you risk another contempt motion that likely would be approved at that time.
Okay.
Okay.
So my only question would be, Your Honor, I'm just back to supervised visits after I was supporting my son now again?
That is the last thing you all asked the court to sign. That's the last thing that the court has signed. That is the order that is in effect. Certainly that's an issue that this court will be addressing when we issue any further orders. But for now, that is the standing order of this court. It sounds like it was issued in the hopes that there would be some evaluations taking place and treatment, and the court would want to see some progress on those before changing any of the prior orders. Okay. All right. We'll see the folks back on August 9th. Please, when the GAL reaches out to you, make sure you promptly return their calls.
Okay. Thank you.
All right. Thanks. You're both free to log out. Okay. So the last thing I have is a review hearing you had on May 8, 2023 that addresses who the primary custodial parent is. Looks like there was some modifications to visitation. And then the court set this review date, presumably to see how those modifications on visitation are going. What can you folks tell me?
I think that they've been going really well. And, you know, we've talked about it and we would just kind of like to move forward to the 50-50. And I myself personally would like to just extend the time that she has from Saturday instead of ending at Monday at 6 and Tuesday at 8. I think to make it exactly 50-50, she'd probably have to have her a little bit earlier on Saturday than 6. But, I mean,
so so is your proposed parenting plan had last been filed February of this year, it looks like. Are you, sir, still sticking with your request from that proposed parenting plan, or are you wanting something different?
I'm wanting something different. Things are going a lot better than what I expected. And I think that we both could be happy with the 50-50, no child support from either one of us. And I think that we could just work this out
And okay, that's really good to hear. On the mother's end, does that comport with kind of your hopes for this case?
Yeah, originally I wanted to do 1 week on, 1 week off, but him and I both agreed that that's just too long without seeing our daughter. She's only 4, so.
Okay. So what I see here procedurally is that we don't even have temporary orders in place, an actual temporary parenting plan. We just have some bench orders addressing kind of small pieces of this. So if you folks, what I think we should do is set a new date for you. We could do that even 2 weeks out if you think you could get something to the court by then. What I would want is your new proposed parenting plan. If it's agreed, if the two of you are working together and presenting an agreed temporary parenting plan to me, certainly makes everyone's life easy. But if there's small pieces that you want me to decide, that's fine too. I would just ask that what we'll do is we'll set a new date. You guys can tell me how much time you want, submit a new proposed parenting plan, and then we'll go ahead and enter that, hear any argument on small sticking points, and then get you guys that order.
So that works for me. If there's any way we can set this out quite a ways out, I'm kind of getting in a lot of trouble for my work, having to take this much time off. So it would actually work out a lot better for me if it could be moved out. And I don't have a problem with, if she was to have more time during the week until that court date. For work purposes, it would work better for me if it was set out a lot more than 2 weeks from now.
Yeah, and that's fine. How much time do you guys want?
Whatever works best for him.
Do you want a month, or do you need more than that?
Maybe a little bit more than that.
Okay. Let's do let's see, we're here on July. So it's July 12th. You want to do September 6th?
Yeah, I think that should work fine.
Okay. So let's set this on for September 6th at 9 a.m. What my notes will reflect is that my assumption, and if things change, that's fine too, but my assumption at that time is we'll be entering a temporary parenting plan for you all. And then we can discuss how you want this case to resolve for permanent parenting plans. Okay. The other thing is you asked for the bench order right now. It allows mother Saturdays to Mondays. What are you wanting? Are you wanting the visitation to have specific days in it pending the next hearing, or what are you asking for?
I would ask that maybe it go till Tuesday at 8. So she'd have another overnight. She'd have Saturday overnight, Sunday overnight, Monday overnight, and then at 8, we can arrange for a place to meet to pick up, and that's how I'd like to do it.
Would that work for you, ma'am?
Yeah.
Okay. And certainly what I'll say is, because we're not doing an actual temporary order or a parenting plan, if this is allowing you those dates, if the parties find that doesn't work, this is not mandatorily the child must be with you during these days, but we are allowing that visitation. So I will issue a new bench order today, extending that Saturday at 6 to Tuesday at 8. Otherwise, all other, visitation remaining unchanged, or custody remaining unchanged. And then we'll address all of those new issues when you submit me a new parenting plan and we come back on September 6th. And then Ms. Looney, you are here on this matter. Is that correct?
The state's involved only as to child support, Your Honor. I'm just observing today.
Okay, great. I see, and what I have from the parties is a request for a restraining order. I have reviewed that request, and so I'll just first ask the moving party, ma'am. Oops, looks like you might be having a bandwidth issue, ma'am. Just go ahead and turn your camera off.
Is that better? Can you hear me now?
I can, and I can, there we go. Yes. So are you still asking the court to move forward with the restraining order?
Yes, please. On the 31st of May, I had one set aside to try to work things out and allow him to see Lincoln, and that did not work out. So he said that I could put that back in place if I needed to, and then I did.
Okay.
I requested a new one.
Okay. And sir, are you objecting to this restraining order being put into place?
Yes, I am, Your Honor.
Okay. So let me go ahead and give me just a second. My concern with moving forward, I'm looking, when you last brought this, ma'am, it was May 31, 2023. And it does address the statement that you were going to be working with respondent at that time, so it was dropped. But the court's ruling actually was that it was denied without prejudice because we were concerned about jurisdiction over the child.
Yeah, sorry, go ahead.
Yeah, so I mean, I'm just wondering what the folks can tell me about that.
Your Honor, this is
So my
Ms. Looney. I may be able to help. I may be able to help with that.
Yeah, I'm going to let Ms. Looney give the court some insight here. Thank you.
Yeah, the state was the one who brought that concern forward, so I thought it might be helpful if I laid that out.
Absolutely.
Initially, this was brought regarding a parenting plan. The child had only been living in Washington with the mother since February. But the real question at this time was that we did not have parentage established for the child legally. So the state's concern with doing a parenting plan was that we did not have parentage established, so we could not move forward with child custody or child support matters at that time.
And has anything changed since May 31st?
Not to the state's understanding, Your Honor.
Yeah, looks like the last thing the court did on jurisdiction was in June, noting that a UCC JEA conference was needed. It does not look like that's been held. So what I see, ma'am, is I won't be able to enter this order for you today. I can put in a request for this court to hold what's called a Uniform Child Custody Jurisdiction Enforcement Act conference, where I would, likely me or some other judicial officer, would be working with a judicial officer in Oregon to determine who has more substantial contacts and therefore could exercise jurisdiction over the child. And that's the best I can do for you today would be to, I could set this matter over about 30 days. And then when I can get the UCC JEA conference scheduled, I would notify both parties so that you can be present, because the Oregon judicial officer and I would be asking questions to determine who has more substantial contacts with the child.
All right, that is fine. Is there anything I need to do except wait for that court date from you?
No, let's set a 30-day review date on this matter, though, just so this doesn't get lost in the shuffle somehow. And I'll just tell you, sometimes getting these UCC JEA conferences can take some time. There's a lot of coordination with schedules, but let's reschedule a review on the jurisdiction issue to August 9, 2023 at 9 a.m.
I also wanted to clarify something that Ms. Looney said. He is not returned to my legal custody in Washington on April 24th, not February.
Yep, and those are issues that we'll be addressing when we do the UCC JEA conference. So again, this court will reach out to you when that date is set so that you both can participate. So for now, I'm going to deny, again, without prejudice, which allows you to bring this back at any time if jurisdiction is established. I'm going to deny without prejudice the restraining order based on lack of what I believe is jurisdiction at this point and the need for a UCC JEA conference. And then, did I say September 9th? We'll see you back, or August 9th, excuse me. We'll see you back on August 9th at 9 a.m. to this docket.
Thank you, Your Honor.
Okay. Anything else, sir, on your behalf?
Yeah, last time I saw my son in the flesh was April 19th. That's the last time I saw him. And then this is the third restraining order I get. See, I get a like last time I talked to the judge, it was on last time I saw yeah, that was last time I saw Lincoln. Last time I talked to him was on June.
So I'll just Yeah, and I understand the position you're in. I can't until I can establish jurisdiction over the child. I cannot make any rulings, decisions, or otherwise regarding your visitation, a parenting plan, a restraining order, any of it. So unfortunately, I understand your position. I just won't be too much help for you today until we have that conference.
Okay. What can I do to be able to see my son? Because I can't see my son at all. Like, I mean, we got the restraining order, but like, how do I get in contact with him? Like, his mother's made it very clear that she wants me to have nothing to do with my son's life at all.
All right, sir. So what I just said is I can't address anything that has to do with visitation right now until I establish what state has jurisdiction over the child. I understand the position you're in. If you want legal advice, please reach out to a legal aid clinic or an attorney. Perhaps they could give you some guidance. Okay. Otherwise, we'll see you back here on this docket August 9th. And you should hear from the court before then about this jurisdiction conference. Okay.
Okay. All right.
All right. Thank you both. You're free to log out. Thank you, Ms. Looney. I'm going to